Thank you, ladies. First order of business will be approval of the minutes, February 5th, work session, and February 6th, 2024 meeting.
I'll make that motion.
I'll second. Call for a vote.
Aye.
Aye. Approved. Mr. Wilkins, we have report of the warrants.
Commissioners, I have warrants from February 7th in the amount of $634,727.65. There was just two that was not at normal bills. The quarter or the semi-annual contribution to the airport for $300,000 and our fiscal year dispatch for the sheriff department for $88,725. Everything else was normal bills.
All right, sir. Thank you.
I do have one claim.
All righty.
It is check number 390564. This is the balance of the emergency we had on Christmas Day at the Western Park. We had to purchase a fire hydrant to replace one that had problems for $4,770.75.
All right. Do I have a motion?
I'll make the motion. We go ahead and a claim for the Western Park water line repair for $4,070.75.
$4,770.75.
770.
$770.
And I'll second. And then vote.
Aye.
Aye. Okay, any tax matters? Okay. All right. Moving along. Now we have a ordinance number 120420, correction, ordinance 1204-202301, vacating a portion of a certain Class B road, 1250 North, located in Uintah County on private property owned by Christi Jenkins in Township 4 South, Range 21 East, Section 17, SLM, and revision to the Uintah Transportation Plan map. Okay. This has been an ongoing investigation, partially, trying to figure out what to do and what not to do. There are claims that it was never a county road, that it was in fact never touched by the county on any work to it at all. There's nothing that has been found in any of the work equipment or work orders at the county road shop indicating that anything had ever been done on that road. It's been indicated that the Jenkins, Hackfords, and relatives have been taking care of that road year-round, and they have been using it as a lane. We have asked that the attorneys try to get together and come to some sort of agreement prior to today. And I see we have two attorneys in the room. Were we able to come to any conclusion one way or the other?
We have not. I haven't spoken to
You need to come up with
Would you come up and introduce yourself, please, and use the mic? I'm sorry.
Thank you, Commissioners. My name's James Tracy. I am an attorney. Both Will Reynolds and I have been working with representing the Oviatt Family Trust. T.J. Batty's here. He's one of the co-trustees as Marietta Oviatt Shearer. We have not come to any agreement. We actually haven't had any discussion. I haven't talked to Mr. Labrum for several weeks about the matter. I did talk to Will Reynolds, who was here and gave you some of our positions at your work meeting. He wasn't able to be here today, so I'm covering that today. But I do have some thoughts when you're ready, and if you'd like to hear those, I can give those to you now. Or if you'd like, I can wait until Mr. Labrum talks.
I don't think that was a question if you had anything done. We're not going to discuss it. Myself and Commissioner Horrocks will discuss it, but it's past time for discussion.
Okay.
Okay. But thank you.
There was a question as to whether there are a couple of items, Commissioner, and I appreciate your time today. There was a question on the report that came from the zoning and planning that said that all of the property owners that lived up that lane hadn't signed off on that. We do have a signature from Clifton Hackford and Shirlene Hackford. They're selling that property to Robbie McClure, and he signed off as well. We have that. We'd like to submit that. And then I just had a question. They've said there was a question as to whether this was because of what the law was back in 2003. I've pulled the code and actually spoke to the planning office, and they're the ones that actually sent this to me. I've read the pertinent code back in 2003, and I think she met that. I may be wrong, but I think it would be very fruitful to be able to discuss that for a second, and then maybe Mr. Tracy and I can speak. But I'm looking at what was required in 2003, and the maximum width requirements. The width requirements for any building site for a dwelling shall be 100 feet measured at a distance of 30 feet back from the front lot line. The next code number they gave us and cited was 17.08.195, and that's frontage. It defines frontage as, frontage means all property fronting on one side of the street between intersecting or intercepting streets, or between a street and a right-of-way, waterway, or end of a dead-end street measured along the street line. An intercepting street shall determine only the boundary of the frontage of the side of the street which it intercepts. I don't think any of that applies. And then the other code that they brought to our attention is under 17.08.285, and that's lot. And lot means a parcel of land occupied or to be occupied by a main building or group of buildings, and that would be main or accessory buildings, together with such yards, open spaces, lot width, and lot area as are required by this title, and having frontage upon a street.
Okay,
And
thank you.
having frontage upon a street. In 2003, she had frontage upon a street. Without this becoming a county, that's been the argument from the beginning, that
Okay, thank you.
back in 2003. So.
Can you enlighten us any further, sir?
Yeah.
Please, Matt?
So frontage on a street, like you read, it's required 100 feet of frontage on a street. If 1250 North wasn't there and wasn't a street or a road, then the frontage would have come off of 3000 West, which the parcel has 33 feet of frontage along 3000 West. So it was short of the 100-foot requirement. There wasn't a flag lot ordinance back in 2003. That came into the ordinance in 2006 or 7. And so that's all we were saying, is that the
With the
property didn't have the proper frontage of the 100 feet that was required in the RA1 zone at the time.
Okay.
So, and I think Mr. Laborman explained it well, what the frontage is, and if 1250 wasn't a road, then the frontage would come off of 3000, so that'd be the 33 feet that she owns there along 3000. So that's all, and that's on the maps.
Now, did not her family own further, more of that property? I'm trying to think, I'm not
Yeah,
sure.
I think her family owned further north, and they still do.
Okay,
But from what I can see, the parcel was the same in 2003 as it is today.
as it is today, okay.
So, from what I can gather, but I mean, really, that's been part of the discussion, is that, that 1250 North could have been used as the frontage, but we don't know that for sure at this point. There's nothing in the building permit record that shows that. So,
All right, thank you.
Commissioner, I don't know if I could just take 2 minutes?
My second hand is ticking.
Okay. Because I haven't been here before, I did want to just say basically one thing. It comes down to what we think is fairness, and we don't think it's fair to other property owners who use that county road to access their property to have the public nature of the road removed. And when we say, well, it's not fair, well, in legal terms, there's actually 3 constitutional provisions that apply: the due process of the 14th Amendment, the Equal Protection Clause of the 14th Amendment, and the Utah Constitution. And the gist of those are that government can't favor one person over other persons. And there's really, if this ordinance is passed, there's really no other way to look at this other than Ms. Jenkins has been benefited as a property owner, but my clients who own 2 parcels of property it'll be to their detriment and in dereliction of their private property rights, because this is how they access their property. And roads become public roads. This under 72-5-104, a road's dedicated to the use of the public when it's been continuously used as a public thoroughfare for a period of just 10 years. I think this road, is undisputed. It's been being used for 30, 40 years. So regardless of how it got done, it's been being used as a public road for many, many years, and we think it should stay that way.
Commissioner, we have a certificate of occupancy that was issued by the county.
Thank you.
We also have the takings clause of the U.S. Constitution, and there is 0 evidence that this has ever been used by the public. There is no evidence that's been offered to anybody that anybody's ever driven this. In fact, I would respectfully put forth, if Christi knew what the situation was prior to the Ovietts passing away, and she would have brought this before the commission, the Ovietts never used this. Part of the Oviett family is saying, everybody knew that wasn't our road. We didn't access our road through there. They accessed it through their own property. They never accessed it through this lane. And so we just don't understand. I mean, if we would have brought this before the commission and seen that it was on the map prior to that date, I've pulled other maps. I've pulled Google Maps. Google says that there's a road that runs clear up through Christi's place, and that's not a public road. Just because something's on a map doesn't mean it's a road. It has to show use, or it has to be dedicated over or deeded over to the county, and neither one of those things have happened. And just because somebody wants to go, they've tried to push this as fast and as hard as they can in order to get concrete put down and get it setting up so that people say, oh wait, we can't pull that concrete out of the ground now. If we would have had this discussion this time last year, I don't believe that this ever would have been approved. A minor subdivision never would have been approved back there, because the evidence comes out and people say it's never been used.
Okay, we're not,
You know, anything like
we're
that?
not gonna take testimony. We're just listening to the facts, or trying to listen to the facts. All right.
Are
Thank
there
you.
any questions that I can answer?
I will be glad to ask them if I have them. You
Okay,
know me better
okay.
than that.
Yes, thank you.
All right, let me point out also, I've received phone calls from both Joelle List, I'm sorry, all I could think was Oviett, List, and Philip Oviett, which are both also half of the trust. They both have advised that they have no knowledge that that road was ever a county road, that the Jenkins family, Hackford family, and their were great neighbors, and they took care of that road all the time, that the county, as far as they knew, had never been on it. Their opinion is it needs to be vacated. So that's their side of it. What we were hoping for, no, we're good. Unless you can give us just facts.
I can give you just facts.
All right, make it snappy. I will cut you off if it's more than just facts.
Yes, sir. The only way that a truck or tractor can enter onto that backfield of the Ovietts is through a gate that is on that road. And so they used to keep sheep, and they have sold hay to my family. What they've cut off of that field using the only gate that is on that road.
Commissioner, I do have just a response to what the Oviates told you, and it'll take 30 seconds, but. So just to clarify, Joel and Philip, they are beneficiaries of the trust. They aren't the trustees. And when Mom died, she had in her trust very specifically exactly how to divide up that property. It's been divided exactly the way she asked it to be divided. They don't like that. They want a different division. And I talked to Mr. Bullock, their lawyer. He actually says they want the road to be vacated so that they can argue somehow that the subdivision that their mom wanted shouldn't be done. So it's really leveraging between these family members, but they're just beneficiaries. They're not the trustees. That property was divided exactly the way Aura wanted it to be.
You want me to explain what the ordinance says as it's currently written?
Please.
So you remember at the last work session meeting, John Sturmer, who's not here today, his recommendation was to vacate a portion of that road. So the road would extend 90 feet past the west lot line of the minor subdivision. So that was his recommendation, and that's what the ordinance currently says. That's how it's been drafted. And the map shows that there's 90 feet past the westmost property line of the minor subdivision that was approved.
Correct. Thus
keeping frontage on the minor subdivision lot and the lot that was to the west of that. So I just want to explain that's what the ordinance says. Now it can be changed, but that's how it's currently drafted.
No, thank you. You put in words that I was going to say.
Okay.
I was aware of that, very much so.
I've got a strong conflict, both sides.
It is with great dissatisfaction that I have to say, attorneys, this should be handled, we shouldn't be handling it. Commissioner Horick says he has a conflict, he will not be making a decision. I'm a party of one, I'm not gonna make a decision by myself, it takes two of us. How much time do you two need to sit down and talk? Can we get it crushed out today, do you think? Or is it a no-win situation, or do we need to even worry about it? Just put it on the schedule when Commissioner Norton's back and we'll deal with it.
Commissioner, if you give us 5 minutes, I think we can do that. I have some questions for Mr. Crozier as well, as far as if there's been some discussion that I understand that if we shortened the road, maybe there was possibly that situation that happened, they would still be able to access that new lot that's back behind, some things like that. So,
My client says he's okay with the ordinance as explained, which means it's still a county road up to 90 feet west of the property line of my client's property. If I understood that correctly, that seems to.
We've got two mics, why don't each of you take a mic and let's talk it out so we can get it figured out right now. Please identify yourself again, even though you have.
James Tracy on behalf of the Oviatt Trust. Mr. Batty, who's a co-trustee, if we understand the ordinance correctly, what I think I heard him say was we're going to keep it a public road, county road, up to at least 90 feet west of the property line of our lot. And I think that lot is the lot ending in 031. So lot 041, 020, where there's I think this is east, right? Going towards the homes? 3,000. Right, so the eastern boundary of that, if the road could stay a public road to 90 feet, I think he said, past that, my client says they're okay with that.
I say we're just gonna get this worked out before we even move forward anymore.
Mr. Crozier was running up to grab his laptop so we could
Okay.
pull up an aerial photo.
Okay.
And my question for him is how many homes they'd be allowed to build if they were allowed to get back up in there and do that. And Christi does have some pretty major concerns that she's giving up property and things like that, but
Am I gonna be the one to maintain it still?
well, I think
The
then,
little bit of traffic that's been on there has tore it up.
and that would be the other concern. There's, according to my client and her family, no one's ever traveled that, and in the last couple of months since we had those last commission meetings, I have a stack of pictures this, 1/4 inch thick, that people have parked on the easement. For the first time, they've started driving a truck and trailer, bringing stuff out of that old house the back way on that soft road, and have just torn the heck out of it. Christie's pulled out several times. It's really narrow. It's
It
only
is.
30 feet between the power poles.
I've been down it, it's very narrow.
And so she's pulled in at night and there's somebody parked there.
Well.
And she has no way of getting around or anything else, and that would be one of her concerns. So I think if it's public though, you can call
I think what we're gonna do is we're gonna continue this, Matt. You've asked some questions that I can't answer. If it's gonna be a county road, it's gonna have to be widened. I'm sure we'll have to see what the specifications are. We'll check with county roads and see what their requirements are, just to make sure that things are covered that way, because it is a
Commissioner,
Class
one
B.
thing that we found down in the recorder's office, there were maps kept. And you have certain sections, and the plat maps that were kept between 1987 and I think 1992, someone had hand drawn on there a road, and on their section lines. So this one belongs in a book and this one belongs in a book, but when you marry them up, it shows coming from Christie's side and then coming from the Oviatt side. It shows a road that goes on both sides of the section line, which would go 15 feet into the Oviatt's property. And so what I would suggest is if the Oviatts, if we can go where that road was originally designated, or at least drawn in there, go up 15 feet on their property and 15 feet on Christie's, I think should be happy to give that up. And then they're giving something, and Christie's giving something, and everybody gets what they want.
Okay, we'll table this for the 27th, we will make a decision. It looks like Commissioner Norton will be available that day. And gentlemen, please get it worked out before then.
Okay,
If not, we will work it out for you that day.
thank you. Commissioners, we appreciate your time.
Thank you, gentlemen. Okay, it's time for public comment. Public comment will be for public comment, not public debate. County will listen to the comments made to take them into consideration. The county will not be responding to comments or answering questions. Comments might be, or they might not be, something the county has the power to act on. This is a recorded public meeting. If someone would like to make a comment, they need to wait until the microphone is available. Please come up to the microphone, either one. State your name for the record. Please be respectful. There'll be no interrupting. And please wait your turn. You'll have 3 minutes apiece for a total of 12 minutes. Do I have anybody who'd like to make a public comment? I see no one.
Just for records, our longtime commissioner here, Dave Haslam, passed away, I think this morning or last night. Just for public information and respect to him, and just that.
First I heard of that. I'm
That's
sorry
what
to hear that.
I was told just a few minutes ago, so. And I'll make the motion, we are adjourned.
We are adjourned. I'm sorry to hear that. I didn't know.